This is Democracy Watch. Mark, we just saw something that I did not think we would see, and that is Jefferson Griffin conceding. He is the Republican candidate for the North Carolina State Supreme Court, conceding to Allison Riggs after a long, drawn-out 6-month process where he tried to subvert the will of the voters by casting out more than 60,000 votes. Can I have your reaction to the fact that he finally did concede, and why do you think he opted to do this now after, again, dragging this whole process out and trying to undermine a free and fair election?
So count me among the people who would tell you that Jefferson Griffin doesn't deserve any credit for conceding. I mean, as you point out, he strung this out for 6 months. During that time, there was a full recount. Then there was another partial recount. He lost both of those. Then, as you say, he tried to disenfranchise more than 60,000 North Carolina voters. He went to state court. He went to federal court. And he kept fighting and fighting and fighting to disenfranchise these voters. And it was only after he lost in a sweeping decision that you and I talked about in federal district court before a judge appointed initially by Donald Trump, a conservative judge. It's only at that point, facing the prospects of his only chance to go to the Fourth Circuit, which was never going to reverse the trial judge in this case, that he decided to concede. And even then, he did it in kind of a grudging manner. You know, he said that he disagreed with the district court judge. But, you know, like, what other alternative did he have? It wasn't like there was much left road for him here. So I guess I'm glad that he didn't take the election denier route that Donald Trump took. But, you know, I think credit only goes so far here.
I completely agree. Why do you think he didn't try to push this thing past the Fourth Circuit up to the Supreme Court? Do you think the Supreme Court would have touched this thing with a 10-foot pole?
No. I mean, look, this is the thing. Like, he literally ran out of runway. He lost in federal district court in an opinion that made very, very clear that this conservative judge was frankly outraged that he had brought these claims. I mean, these claims here were essentially that he gets to change the rules of voting after the voters have voted, that he gets to target which voters he applies those rules to, because he wasn't challenging 60,000 people across the state, only in certain counties with large Democratic constituencies. And the judge rejected this. And so, you know, I think he looked at the composition of the Fourth Circuit, which, you know, leans more center left, yeah. Right? You have more judges appointed by Democrats than by Republicans there. And so he would have had to go to the Fourth Circuit, lose in the Fourth Circuit, and then seek cert in the U.S. Supreme Court and hope that they weigh in. All along, by the way, Brian, assuming that he'd get a stay. Right? Because, like, you know, the trial judge said, I'm going to stay my decision ordering the certification selection for 7 days. And, you know, as you and I think, talked about, like, there was nothing in that opinion that suggested the judge was going to extend that courtesy beyond 7 days. Right. And I don't think the Fourth Circuit would likely have stayed this. So it probably would have run out of road even before it got to the Supreme Court, because the election would have been certified. But in any event, no, I don't think the Supreme Court would have taken this case. The Supreme Court is busy, as you might have noticed, with a number of other cases that the President of the United States is insisting that they take because he's losing case after case. So I think Jefferson Griffin did the only thing that was available to him.
Do you think that the reason Jefferson Griffin didn't want to go up to the appeals court is because the appeals court is where precedent is established? So he can lose at a federal trial court and it doesn't establish precedent. But if he were to bring this case up to the Fourth Circuit and they did indeed rule in agreement with the federal trial court, then all of a sudden that undermines perhaps other Republican plans in other Republican states where they want to do the same thing, but where official legal precedent would actually make that more difficult.
Yeah, look, I think that is a reason why his sort of co-parties and all of this, right? His backers in this, the Republican Party of North Carolina,
right?
The Republican National Committee. I think that's why they didn't want this case going further, because they did not want the Fourth Circuit to write an opinion that would have more binding scope in a further geographic area, and also, as you say, be precedent that other states would have to look to, even if not bound by, would be quite influential. And again, remember, Brian, he got a very bad opinion out of a conservative district court judge. I mean, one can imagine what the Fourth Circuit opinion would have read like. It probably would have gone further, and it probably would have been even more excoriating of these efforts. So I suspect for Jefferson Griffin, who I don't know, so I don't know what motivates him, but I suspect for him, some of this was just a matter of like pride or not wanting a bigger court to say meaner things. And also it may have been that, frankly, the financial for this had backed away. I think for the RNC and the North Carolina Republican Party, then, yeah, I strongly suspect that they were not looking to enshrine into the law, worse outcomes that would have more impact. But look, Brian, this is now, I'm going to just say, like, my law firm was involved in litigating this case here on behalf of voters and progressive nonprofits. And we litigated a lot of cases on behalf of the Biden campaign and others in 2020 and other groups in 2022. This is now a long string of cases in which the Republican Party and its candidates have simply been unable to get courts to bite off on this really, really problematic effort to change the rules afterwards. So it's a good win. I think that Jefferson Griffin, like I said, may have had his own motivation, but the RNC, they, as you say, they didn't want precedent that was going to make this harder because they're not going to give up. They're going to keep, I am, as sure as I sit here right now, they will find another opportunity to try to advance this fringe theory.
Mark, I understand that by virtue of not going to the appeals court that there is no official precedent, but does the fact that even a Trump-appointed federal district court judge come out and shut down these efforts by Republicans and Jefferson Griffin, does that at least offer up some atmospheric precedent that other courts can look to if and when Republicans try the same thing elsewhere?
Yeah, so the way to think about it is this way, is that district court decisions are not binding precedent. They do not force other judges, even other district court judges, to follow their outcome. Court of Appeals decisions, the Fourth Circuit would be binding within the Fourth Circuit, which is several states, right? Yeah. So it would put the Republican Party in a much worse situation because that would then be binding on all of the district courts in those states, and it would be highly influential out of its own jurisdiction. So in other words, even if you were in another circuit, the fact that the Fourth Circuit had resolved this big election dispute, there aren't that many big election cases. If the Fourth Circuit resolves a big election case, that's going to have really strong influence even outside of the places not binding. Here, as you say, this is a well-respected, very conservative judge. I mean, this is not, easily sort of shaken off by Republicans elsewhere. It's not binding in any other court, but it will be influential in the sense that another judge faced with a similar fact pattern will read this decision and they can take notice of it. They're not required to follow it, but the fact that it was a written decision, a thoughtful decision in which a conservative judge wrote a pretty sweeping opinion, sure, that will have some influence in the future. But, that's not going to stop Donald Trump and the Republican Party in 2026 from trying to roll these theories out elsewhere.
Right. Mark, we've spoken about this issue that I'm going to bring up right now, but I'm still having trouble reconciling this, and that is that you've got a Trump-appointed federal district court judge for whom this issue, even for him, was too far off base for him to sign on to, and he duly shut everything down. But it doesn't negate the fact that there were still North Carolina Supreme Court judges and North Carolina appeals court judges who agreed with Jefferson Griffin's position and allowed it to get that far. And so we can sit here and applaud the fact that the forest fire was put out, and it was, but we're still kind of ignoring the fact that the arsonists are still walking free. And those arsonists, in large part, were also these judges in the state court system in North Carolina who allowed this, who not only allowed this process to perpetuate, but were part and parcel of it. They enabled the whole process. They agreed with Jefferson Griffin in court and basically perpetuated this farce where he can throw out tens of thousands of properly cast legal ballots. And so I guess what is your reaction to the fact that, again, we can sit here and applaud the fact that there is some sense of justice now that Allison Riggs will be able to have her election certified, but like these people are still walking free. They're still handing down rulings, and they are part of the problem.
Yeah, and look, Brian, this is a place where you're 1,000% correct, and your insight is really welcome because even I here am a little bit guilty of letting the Overton window having shifted, and you're right to call that out. I mean, we cannot lose sight of the fact that we are only in the position of having a federal district court judge as a safeguard, as like the last line of firefighters. Like it's not even the first line of firefighters. Like literally, as you say, this went through the entire state court system.
Right.
This federal judge was there to essentially protect the federal constitution and the federal rights from being impinged upon by the outcome of a fully litigated state court system.
Right.
From
bottom to top, all the way to North Carolina Supreme Court.
And those state courts should have also been, protecting those rights. Right. And it was kind of like the fail-safe here that the federal courts who were backstopping those had to functionally block, or not even functionally, had to block the outcome of a state court litigation proceeding, saying state courts, what you have come up with violates the federal constitution. And that is no small matter. So I think you're exactly right that this was not the courts in their finest hour. Like this was, the last opportunity, the federal court backstopping the state court system. And the people of North Carolina, the citizens of North Carolina will now have to go back to their daily lives with this state court system, right, in place. Sure, Allison Riggs will be on the court, but it is still a 5-2 court, 5 Republicans, 2 Democrats court. That court is in place, and there have already been some rumblings, Brian, in some of the right-wing press that I have been reading, that they're like, okay, well, maybe this failed for this election, but we still have these precedent in the state court system.
Right.
And we should be able to rely on these precedent in our state court system. And, so, am I worried about that? I am. And I think you're right to call it out, that we should be celebrating this, but also recognizing how extreme the circumstance got that it never should have gotten to.
Well, look, I'm proud that both of us have covered in depth what is happening in North Carolina from the very beginning. I think that we both know, and our audiences are well aware of the fact that Republicans were trying to use this as a test case for their broader effort to undermine democracy across the country. Luckily, we were able to stave off this effort for right now, which, to your exact point, does not mean that they won't try to do it again in the future, because they absolutely will. But to the broader point here, I think we take the wins when we get them, and know that come tomorrow, we live to fight another day, and there will be another fight on exactly this issue. To my audience who's watching right now, highly recommend that you subscribe to the Democracy Docket YouTube channel. This way you can see more analysis by Mark and his team, and that analysis is excellent. So if you are subscribed to this channel, if you're watching this video, please hit the link right here on the screen and make sure to subscribe to Democracy Docket. I'm Brian Tyler Cohen.
I'm Mark Elias.
This is Democracy Watch.